Thank you for joining us and for your patience whilst we figure out Zoom's constant surprises. Welcome to the fourth and last EDI Forum of the year, organised by the INS EDI Steering Group. I'm Emma Jeffrey, the Assistant to the Director of Membership and Education. This evening's talk is on the Equality Act 10 years on with keynote speaker Karon Monaghan QC. Master Karen Shuman will chair the event and introduce tonight's speaker. The talk will be followed by a Q&A session, and for this we would ask you to please put your questions in the Q&A function, not the chat function. The Q&A function can be accessed on the Zoom menu bar. You just click on Q&A. This will allow you to ask anonymous questions and to upvote questions that you find interesting and would love to have answered. If you have general comments or questions not related to tonight's topic, please put those in the chat. Me and Clara, who's also here this evening helping us, will try to answer any general questions you may have. If you have any problems with internet connection, we suggest making sure that no one else is streaming in your household, and if necessary, logging off and logging back into the webinar. If your problems persist, you can email us at education@lincolnsinn.org.uk. If you have any feedback about the event, we would love to hear it, so please let us know by email, the same email address, education@lincolnsinn.org.uk. We will be recording tonight's event, and the video will be put up on the INS media page by tomorrow afternoon. We'll make sure to share the link on the INS social media as well. On behalf of the IN, I'd like to thank Karon Monaghan QC and Master Shuman for giving us their time this evening, and thank you all for joining us. I'll now hand over to Master Shuman.
Thank you, Emma, and good evening, everyone. I think the irony is not lost on me that my judicial title of Master seems quite rich when the talk of the speech tonight is Equalities Act 10 years on. That's a conversation for another day, I suspect. So I have the privilege tonight of introducing Karon Monaghan QC. Karon is a leading public law and equality practitioner. That is often bandied around, but it is absolutely certainly true in Karon's case. She is a specialist in the fields of equality and human rights law. She has appeared in numerous cases at appellate level, the Supreme Court, the Court of Appeal, the Court of Justice of the European Union. And if I just give you 3 examples of some of the cases that Karon has been involved in, you will get a flavour of the depth and experience that she has. Gillam and Ministry of Justice, that was a case in the Supreme Court in 2019. A district judge claimed that she was a worker for the purpose of employment rights and so could claim whistleblower rights. She succeeded, so now judges have whistleblower rights, and Karon represented the judge. R. Stainfield and Caden against the Secretary of State for Education, another case in the Supreme Court, that was in 2018. And in that case, the appellants were a heterosexual couple who were in a committed long-term relationship with ideological objections to marriage, and they wished to enter into a civil partnership. And they argued that once same-sex marriages were permitted, which was from 2013, it was discrimination against heterosexual couples not to allow them to enter into a civil partnership, when same-sex couples could choose to enter into a civil partnership or marry. And Karon represented the successful appellants. And again in the Supreme Court in 2018, D against the Commissioner of Police of the Metropolis, Liberty and others intervened in that case. And I suspect you will know this case, if not by that name, you know it from these facts. A serial rapist administered drugs and alcohol to passengers in his taxi cab, which enabled him to commit serious sexual assaults, and he attacked over 100 women before he was caught. And 2 of his victims claimed compensation and declarations under the Human Rights Act against the Metropolitan Police for their failure to conduct effective investigations. It was said to be a breach of their Article 3 rights. They succeeded and they were awarded compensation. And the Metropolitan Police appealed to the Supreme Court on the narrow issue of the nature of the investigative duty owed under Article 3. Their appeal was dismissed. Karen represented some of the interveners who successfully argued that there was a positive obligation on states to effectively investigate reported crimes perpetrated by private individuals. Karen is a member of the A panel of the Equality and Human Rights Commission panel of Preferred Counsel and the International Labour Organisation's Committee of Experts on the Application of Conventions and Recommendations. She is a visiting professor in the UCL Faculty of Law. She's acted as special advisor to the House of Commons Business Innovation and Skills Committee inquiry into women in the workplace, a special advisor to the House of Commons Treasury Committee inquiry into women in the city. She's also a matron of the Foundation for Women's Health Research and Development Charity. And Karen acts for NGOs, statutory bodies, has an extensive advisory practice, acting in, conducting and advising on statutory and non-statutory inquiries and investigations. And I also, when I was carrying out some of my own research, I noticed that Karen had authored a recent report, that's in August of this year, Karen, just to give you a tip as to what I'm going to mention. And she investigated sexual harassment and the management of sexual harassment complaints within the GMB. And I think this gives you a flavour of the very clear, direct conclusions from her investigations on what a body needs to know. And in the executive summary, it says, the GMB is institutionally sexist. The general secretaries and all regional secretaries are and always have been men. Women are underrepresented throughout the GMB's ranks. She went on to say there is significant job segregation at regional level, with officer grades disproportionately filled by men and staff grades disproportionately filled by women. Branches are male dominated with limited female participation. Bullying, misogyny, cronyism and sexual harassment are endemic within the GMB. So with that introduction and the expertise from Karen, I turn to you, Karen. Thank you.
Thank you. And just before I start, I should say, just speaking to you, Karen, Master Shuman, of course, I am, as you referred to, a matron and not a patron of an NGO that I'm involved with. And there was lots of discussion about whether or not matron worked. And we decided if patron did, matron did. So maybe we'll see you as mistress at one point. Not sure that quite works, but anyway, so the Equality Act, as you will all know, I'm sure, it was enacted on the 8th of April 2010. Its main provisions came into force on the 1st of October 2010. At the time it came into force, it was greeted with considerable enthusiasm. There were endless conferences, endless papers written. Everybody working in the equality sphere really thought this would herald considerable change and progress equality through the law for all, but in particular for marginalised and disadvantaged groups, and for those groups that experienced systematic discrimination. It was, too, the first piece of equality legislation, the first significant piece of equality legislation that followed the establishment of the Equality and Human Rights Commission in 2007. That commission had been established pursuant to the Equality Act 2006, and they were seen very much as a package of measures complementing each other. So, for example, the Equality and Human Rights Commission were given specific power to promulgate or to issue statutory codes of practice, providing compelling guidance to public bodies or anybody else falling within the scope of the Equality Act on the terms of the Equality Act and how to comply with it. It also was provided, that is the Equality and Human Rights Commission, with the power to take action in respect of violations of the Equality Act. So very much a package. The Equality and Human Rights Act, the Equality Act 2006, the Equality Act 2006 also brought together the legacy commissions, that is the Commission for Racial Equality, the Equal Opportunities Commission, and the Disability Rights Commission into one overarching commission, just as the Equality Act 2010, in broad terms, brought together the legacy enactments, that is the Race Relations Act, the Sex Discrimination Act, the Disability Rights Commission, and so on. So both package, both effectively unifying measures. As to anti-discrimination more generally, has in fact a long history of enacting legislation against discrimination. Its first anti-discrimination legislation expressed in terms, it's found in the Race Relations Act 1965. That addressed, as its title indicates, of course, race discrimination. Its provisions and scope were narrow and limited, but nevertheless, it was a real historic piece of legislation. Much activity, of course, in the US and at that point, and so lots of learning emerging from that, lots of campaigning, and so our first legislative action in relation to anti-discrimination concerned race, limited but nevertheless very important. That was followed in due course by Race Relations Acts enacting broader and stronger measures against race discrimination, and in due course legislation protecting against sex discrimination, and also inequality in pay related to gender alone, but inequality in pay and sex discrimination, and in due course legislation addressing disability discrimination. All of those were in the main domestic measures. It is true to say that the Equal Pay Act, and to some extent the Sex Discrimination Act, would have to have been enacted in part in due course because of the impact of EU law, but the imperative for them derived in the first place from domestic law. In due course, however, there were a number of other EU measures that required the United Kingdom to enact further legislation covering new protected characteristics. So in 2003, or by 2003, the United Kingdom was required to enact legislation addressing religion and belief, age and sexual orientation. So no legislation addressing those characteristics under anti-discrimination law at that point. So these were fresh legislative measures required by EU law and in the way of EU law implemented domestically. They were enacted under subordinate legislation. So no primary legislation, but enacted in subordinate legislation pursuant to the EU law and indeed the Equality Act 2006. So by 2003 and moving forward, legislation addressing anti-discrimination was patchy, various legislative measures, some in primary, some in subordinate legislation. Whether one was protected against this, that or the other in relation to this, that or the other sphere was very often dependent upon the impact of EU law. There were certain positive duties enacted domestically in the sphere of race, sex and disability on public authorities, what we now describe as the Public Sector Equality Act, which I'll come to. But there were positive duties imposed on public authorities, but only in relation to those areas covered by domestic law, sex, race and disability, not in relation to those characteristics that had come to be protected as a result of EU law, religion, belief, age and sexual orientation. So disparate range of measures all over the place, lacking any coherence at all. Great for the lawyers, endless amounts of work, arguing about what was covered and what was not, and the impact of EU law and the impact of domestic law where it conflicted. So great for the lawyers, but nothing else. So the aspiration for the Equality Act was that it would resolve to the best extent possible all of these inconsistencies and bring the law together in one coherent whole. It was ultimately enacted in the wash-up period after the announcement of the general election that ultimately brought into force the coalition government, so the wash-up period, end of the last Labour government. And so we have the coalition government enacted during that period. Its origins can be found, perhaps instructively, in the Labour Party's 2005 manifesto. That manifesto promised that the Labour Party would promote equality for all, tackle discrimination, and introduce a single Equality Act to modernise and simplify equality legislation. As a consequence of that manifesto commitment, after the 2005 election, it established, that is the Labour government, established the Discrimination Law Review and the Equalities Review to assess in the first place, how anti-discrimination legislation needed to be modernised, and secondly, to undertake a root and branch review to investigate the causes of persistent discrimination and inequality. The Equalities Review, that is the review that was looking at entrenched forms of discrimination and so on, found widespread, entrenched and persistent forms of discrimination and inequality associated with the protected characteristics. So there's a starting point. That was the background. The Equality Act did introduce improvements, a very large number of improvements. Not least, it brought together all the pieces of legislation that had previously existed and that I've just mentioned into a single piece of primary legislation. This itself has brought benefits. It's made the law much more accessible and ironed out most of the inconsistencies. It's also introduced more compelling positive duties on public authorities, including private bodies when exercising public functions. It has also introduced broader positive action measures, so allowing for positive action in a broader range of circumstances. I'll come to that in a moment. But as to the positive duties, the positive equality duties, the mandatory duties on public authorities and those carrying out public functions, those are contained in the public sector equality duty. Public authorities are now required, since the 2010 Act, have been required to exercise functions having due regard, I emphasise due regard because I'll come back to that, due regard to the need to eliminate discrimination, advance equality of opportunity, and foster good relations between groups. Those aspects of the duty are expanded upon in further provisions, making it clear that the purpose of the duty is, or the purposes of the duty, include the need to remove or minimise disadvantages. So it's an outcome-focused duty, minimise disadvantages and meet needs. So it's an outcome-focused duty, but the extent of it is limited to the need to have due regard. So due regard to the need to achieve those equality outcomes. I'll come back to that in a moment. As to the positive action provisions, those extend those found in the previous legislation, which were in any event not consistent, but they make them more coherent and extend them, so that where a person caught by the Act, or a body caught by the terms of the Act, reasonably thinks that people who share a protected characteristic, by reference to gender, race, disability and so on, experience a disadvantage, then they may take proportionate action to address that disadvantage. It's a bit more nuanced and fuller than that, but that in summary is what it's concerned with. There is an important caveat in relation to recruitment and employment and appointment, including of judges, and I'll come back to that in a moment too. But nevertheless, broader positive action provisions, positive duty on public authorities, albeit with some limitations. However, in celebrating those achievements, we need to reflect upon whether or not anything has actually resulted, whether we can see any positive outcomes, besides the fact that we have a coherent whole, which means less work for the lawyers, and that it's accessible. Apart from that, is there anything else? Well, I've already referred to the Equalities Review, which is a sort of starting point, as I described it. That is, what was the position prior to the enactment of the 2010 Act? Persistent, entrenched forms of discrimination and disadvantage connected with the protected characteristics. What now? Well, in the same month that the Equality Act was brought into force, October 2010, the Equality and Human Rights Commission published its first triennial review. The Equality Act 2006, which is, as I've said, established the Equality and Human Rights Commission, required the Commission to undertake a review within 3 years of its establishment, so by 2010, identifying progress against indicators and outcomes which related to the protected characteristics and human rights. So a review overall of progress referable to human rights and the protected characteristics. So it produced its first triennial review, as they've come to be known, 3-yearly review, How Fair is Britain? That report, 2010, so after the Equalities Review, that was part of the pre-enactment discussion around an Equality Act. Post that, same time as the enactment of the Equality Act, it found that men and women in the highest socio-economic groups expect to live up to 7 years longer than those in lower socio-economic groups. Black African women who are asylum seekers are estimated to have a mortality rate 7 times higher than white women. Black Caribbean and Pakistani babies are twice as likely to die in their first year of birth as compared to white British babies. In 2008-9, partner violence accounted for, and that includes ex-partners of course, accounted for 53% of female and only 7% of male homicides. 70% of homicides in England and Wales were charged as a result of racially or religiously aggravated transphobic or homophobic or disability-related hate crime. Educational outcomes differ markedly by gender, socio-economic group, ethnicity and disability. And 2/3 of lesbian, gay, bisexual students in Britain and 4/5 of disabled young people experience bullying. And of course, and as continues and has always continued, or been in place, a very, very significant pay gap as between women and men. Not identified in relation to black women, women from black and minority ethnic communities, and white women, because that measure is generally not adopted. Now, I'll come back to that in a moment when we look at intersectional discrimination and we look at the Bar Standards Board's recent report in relation to pay gaps. But anyway, absolutely stark devastating evidence of serious inequality, not just in relation to employment opportunities, which is devastating, but in relation to mortality rates, bullying, and homicides. And including, I should say, socio-economic disadvantage, absent the protected characteristics, which again I'll come back to in a moment. So again, that's the measure. Where did we start? 2010. We've seen what the Equalities Review says. We see what the position was when the Equality Act was enacted. Where are we now? Well, in 2018, the Equality and Human Rights Commission published its third review, Is Britain Fairer? It found, again, entrenched disadvantage connected with some of the protected characteristics. Some of those, as it found, arose as a result of deliberate government policy, changes to the welfare system in particular. So since 2010, for example, the report found disproportionately, that welfare benefits changes had disproportionately affected a large number of disabled people, women, and people from ethnic minority backgrounds. The courts know this very well because there have been a very large number of generally unsuccessful claims challenging the devastating impact on the welfare benefit changes on very vulnerable minority groups, women, children, and those from ethnic minority communities. So it found really severe impact of the welfare benefit changes. The disability pay gap continues. Black, African, Bangladeshi, and Pakistani people are still the most likely to live in poverty and deprivation, and not touched upon when I reviewed the research a moment ago, but Gypsy, Roma, and travellers face multiple disadvantages, including really, really low mortality rates, serious mortality rates. The Black Lives Matter movement too has shone a light on this year in particular, on other things, police brutality and discrimination in the criminal justice system. This too has been picked up in a large number of reports, but just the week before last, not actually attracting a very great deal of publicity that I could see. It was the US elections, but nevertheless. On the 11th of November, the Joint Committee on Human Rights published its report, Black People, Racism and Human Rights. That was a piece of work undertaken in particular following the killing of George Floyd and the protests that followed, including in the UK. It found that the majority of Black people in the United Kingdom, over 75%, do not believe their human rights are equally protected compared to white people, including in the spheres of education, employment and crime. And those perceptions are well-founded, as the research has demonstrated. Vast majority of people in the Black people in the United Kingdom, 85%, are not confident that they would be treated the same as white people by the police. And those perceptions are well-founded too, as very many numerous reports over very many years have concluded. We know, for example, and these are just plucking out examples, I had a whole list and I've struck out the bullet points because it could go on and on, but we know, for example, that Black people are still 9.5 times more likely to be stopped and searched by the police in England and Wales. And I can't emphasise that enough, 9.5 times. There is no explanation for that, in my view, apart from race. More than 5 times likely than white people to be subject to force by the police, and 8 times more likely to have tasers used against them. So, and 17%, disproportionate number of Black people killed in custody, dying in custody, forgive me, that was the time, dying in custody. So very stark figures, particularly post the BLM demonstrations and protests last year and this year, indicating the extent of race discrimination. And we've also seen the Windrush scandal, of course, showing, in my view, pretty contemptuous disregard by the state towards certain groups of Black people, and the creation of the hostile environment, which indeed was certainly intended in part to create that hostility so far as some minority groups were concerned. So closer to home, I alluded to this a moment ago, closer to home, the Bar Standards Board published a report, I think again last week. We've all been discombobulated by the US elections, but I think again last week, indicating that female barristers are likely to earn less than male barristers, and those from Black, Asian and other minority ethnic groups are likely to earn less than white barristers, and with women from minority ethnic backgrounds being the lowest earning group overall, and with white male barristers being the highest earning group. And just to be absolutely clear, the report explained that that cannot be justified, or explained, I should say, cannot be explained by looking at particular areas of practice or particular areas of call. It found that even when barristers are grouped by their main areas of practice and seniority by year of call, female and ethnic minority barristers still earn less on average than equivalent male and white barristers working in the same areas, same seniority. So clear discriminatory patterns, apparently unexplained, apart from by reference to the protected characteristics. As I mentioned, intersectional discrimination is something that has come up periodically, or I will mention in any event if I haven't touched upon it already. And this is an illustration of how intersectional discrimination works. Here, it's not just that Black barristers or Asian and minority ethnic barristers from minority ethnic groups are paid less. It's that groups within those groups are paid less, particularly women. And we do see patterns elsewhere of Black women experiencing different forms of discrimination or harsher forms of discrimination as compared to, for example, Black men, and conversely, Black men experiencing different or harsher forms of discrimination as compared to Black women. So intersectional discrimination, as we generally describe it, is very important and ought to be captured by the law. It isn't, but it ought to be. As to the bar more generally, there are still disparities. Women at the bar, numbers of women at the bar have increased proportionately, but the proportion of female QCs remains very low indeed, 16.2%. And whenever you say that, there'll be somebody who'll say, yes, but women leave the bar. Well, the answer is, why do they leave the bar? And yes, they do other areas of practice, or yes, they don't apply, and all of that. Fact is, we have consistently had a very tiny number of QCs who are women, and certainly Black or minority ethnic groups, and that ought to change, but it hasn't. And as for socioeconomic disadvantage, which I'll touch upon a moment again, I've already said something about it, but I'll come back to, just keeping an eye on the time. As we well know, a disproportionate number of barristers attended a UK independent school, and by that it's meant private school, between the ages of 11 to 18, as compared to those who did not. So it's all pretty depressing. It is possible to say that there have been improvements here and there. So, for example, depending on where you look at various times and what cohort you look at, there have been some improvements in relation to inequality in pay, as between men and women, still very significant, but some improvements. There have been some greater improvements in terms of autonomy for disabled people, but still very significant discrimination against disabled people, and limits on independent living, and so on, or measures that promote independent living and dignity, and significant discrimination against Black and minority ethnic groups, although some improvements in relation to educational attainment so far as some ethnic minority groups are concerned. But pretty much the picture's bad. And we're now 10 years after the Equality Act, and 55 or thereabouts years after the first anti-discrimination laws as contained in the Race Relations Act 1965. Some of those problems, some of the causes of those problems, I should say, so far as the law is concerned, there are social issues that we can't address by way of law, but some of the issues that derive from weaknesses in the law can be seen in the terms of the Equality Act itself, or the steps taken since the enactment of the Act, so far as giving force to its concerned. So firstly, in relation to socio-economic disadvantage, socio-economic disadvantage is not treated as a protected characteristic under the Equality Act. So those groups who may be from white communities, white poor communities, as well as communities who have other protected groups, do not get the benefit of the Equality Act by reason of socio-economic disadvantage by itself. There is a provision in the Equality Act that at least acknowledges socio-economic disadvantage, and I guess acknowledging therefore the link between socio-economic disadvantage and other protected characteristics, including sex, age, child poverty, for example, as well as race and other characteristics. So one provision does cover it. Important because, as I've said, there's much evidence concerned identifying a disadvantage connected with socioeconomic status. I've touched upon some, but just in relation to pay, for example, we know that in the same job, there is a pay gap of something like £6,400 in elite occupations where the occupant is from a working class background as compared to a wealthier background. Only 5% of students eligible for free school meals go on to study at selective universities, and 65%, coming back to the figure I just looked at in relation to the bar, 65% of judges were privately educated. So really significant socio-economic disadvantage. Probably don't need to tell anybody that. A place one might expect to see that addressed, and among other places, is in an Equality Act, but as I say, not a protected characteristic. One provision does address it, as I've said. Section 1 of the Equality Act provides that an authority to which this section applies, most public authorities, when making decisions of a strategic nature about how to exercise its functions, must have due regard to the desirability of exercising them in a way that's designed to reduce inequalities of outcome which result from socio-economic disadvantage. So due regard to the desirability, whatever that means, but in any case it's very weak, and it's certainly not as strong as the public sector equality duty, addressing the protected characteristics, race, sex, disability, and so on, which requires that due regard be had to the need to achieve certain equality outcomes. So a very weak duty, but nevertheless it acknowledges socio-economic disadvantage and links it firmly within the scope of the Equality Act. Unfortunately, however, it's never been brought into force. Certainly won't be brought into force under this government, I anticipate, but hasn't been brought into force since 2010. Secondly, another weakness one might say in the Act, and picking up from some matters I addressed earlier, Section 14 of the Act covers combined discrimination. That is designed to address intersectional discrimination. It's fairly weak as well. It covers only 2 protected characteristics. Also covers only direct discrimination. So in other words, if you can show that you were directly discriminated against, you were treated less favourably because you were a black woman or a woman who's disabled, so a combination of characteristics, then you can bring claim, or you could bring a claim under the combined discrimination provisions. Weak, as I say, because only 2 characteristics may be relied upon, whereas some forms of intersectional discrimination, some common forms of intersectional discrimination cover at least 3. For example, the treatment of black mentally unwell men, so black mentally unwell men who are disproportionately likely to be subject to restraint, wouldn't be covered by this provision. In any event, this provision hasn't been brought into force either. So no socioeconomic duty, no combined discrimination. Thirdly, the Act still adopts very formalistic concepts of equality. So less favourable treatment. One has to show not just disadvantage, but a comparator, real or hypothetical, which one can identify as having or would be treated less favourably. Even the concept of indirect discrimination, that same treatment, disparate impact, even though that's been liberalised, so one doesn't have to show statistical evidence establishing disproportionate or disparate impact, it's still nevertheless very formalistic. One has to identify a fixed rule of some sort, and although one doesn't have to formally establish statistical evidence, it's pretty much expected. So very formalistic concepts. Fourthly, and as I said I'd come back to, the public sector equality duty, although an improvement on the earlier duties because it covers all the protected characteristics, has become, even if it wasn't to begin with, in essence a bureaucratic obligation. It requires public authorities to have due regard to the need to achieve certain equality outcomes, due regard, and as has been observed by one parliamentary committee, that means even a big local authority can lawfully discharge that duty in the exercising of every single one of its functions without effecting a single change, because it need only establish that it has due regard, or had due regard, to those equality imperatives. So if it can tick off, yes, I looked at all the statistics in relation to women when I decided to make this benefit cut. I knew that it would disproportionately adversely impact on them and their children, but I've had a thought about the economy. I don't want to put up the tax, I don't want to put up the VAT, so I've had a balancing exercise, I've had due regard to the impact on them, tick, there we go. And so the benefit cuts have largely, not always actually, they've messed up a couple of times, but largely the benefit cuts that have caused so much disadvantage and hardship to certain disadvantaged groups, largely they've come in with the benefit of an equality impact assessment first, and so a ticking off of the due regard obligation. So limited impact, in fact. Just finishing off then, as to what equality law should look like, given that we know the Equality Act has had limited impact in terms of outcome. Appreciate the Equality Act isn't the only device that will ever solve social and economic and discriminatory patterns more broadly, but hasn't had a significant impact so far as outcomes are concerned, has inherent weaknesses in it, even without taking account of the fact that parts of it haven't been brought into force. So what then should legislation look like? Sandra Fredman, a professor at Oxford, who is a scholar in the sphere of equality law, has argued that equality law ought to focus and encompass on certain central aims. First, it should break the cycle of disadvantage associated with groups. Second, it should promote respect for the equal dignity and worth of all, thereby addressing stigma, stereotyping, humiliation, and violence because of membership of a group. Third, it should entail positive affirmation and celebration of identity within community. And finally, it should facilitate full participation. The focus of Sandra Fredman's analysis, and indeed in all of her writing, is on outcome. So one must focus and measure outcome, not just treatment. What have we done to stop this happening? Negative obligations, not what are we doing to make sure this happens. So negative obligations, as in the Equality Act, probably aren't going to make a lot of difference. There are many, many positive equality models seen all over the place, in particular in constitutional instruments, South Africa being one example from where Sandra Fredman in fact comes. So positive measures, outcome focus, looking at what's achieved, not what's prohibited, or in addition to what's prohibited. And one final thing, just because I can't stop myself from talking about it, and that's quotas. Huge resistance to the idea of quotas. People bristle at the word quotas. But it seems to me we still should have that within our radar. Indeed, I would go so far as to say we should have them. But at least if we don't have them, we should have them within our radar and think open-mindedly about them. If we look at the position now, quotas have been talked about in the context of judging, not just here, but all over the place. But if we look at the position here, we have learnt, again very recently, perhaps last week or the week before, that Lady Black is about to retire. That will leave, again, only one woman on the Supreme Court bench. For over 10 years, Baroness Hale was the only woman in our highest court, House of Lords, Judicial Committee, and then the Supreme Court, for over 10 years. That was until Lady Black was appointed in 2007. We then had Lady Arden appointed, Lady Hale retiring, and now Lady Black retiring. So going back to one woman in the Supreme Court. So apart from a blip of around 3 years or thereabouts, we will only ever in history have had one woman on the Supreme Court bench, apart from that short blip. And so we need to think about how we resolve that. I think everybody pretty much thinks there should be more women on the Supreme Court bench, and hopefully Black and minority ethnic judges too. Something has to be done. Quotas, as I say, are balked at, but we have quotas. We already have quotas in place. Even in the Supreme Court, we have de facto quotas, or a de facto quota. As you'll know, I'm sure, the Constitutional Reform Act requires that in making selections for the appointment of judges, a selection commission appointed under the Act must ensure that between them, the judges will have knowledge and experience of practice and the law in each 3 parts of the United Kingdom. That has meant in practice that always there has been a judge from Scotland and a judge from Northern Ireland on the bench, always. It's a de facto quota. They're not uncommon, that's quotas, in other jurisdictions, but also in other international tribunals that the United Kingdom sit on, and indeed in the European Court of Human Rights, following provisions passed by the Parliamentary Assembly some time ago, of the 3 nominations put forward by member states for membership of the European Court, judicial membership of the European Court, those 3 nominations must always include a woman. They must always include a woman. There's only one exception ever since that Parliamentary Assembly provision. Only one, and that was Malta, persuaded the court that it wasn't possible to find a woman because there was such a small jurisdiction. Whether that was right or wrong, I don't know. But in any event, it's a quota. It's there. 1 in 3 must be a woman. And many quotas around the world, and there are many, many, many quota systems, including in relation to judging around the world. Most don't have a for this appointment and every other appointment there must be a woman or whatever. It's normally 1 in 3 nominations or 1 out of every 3, and it encourages the looking for women and other underrepresented groups. And I think we really have to come back to looking at that very seriously if we're going to do anything, mindful that even the atypical appointments that we'd hoped would make change, academia, for example, have not resulted in the recruitment of any more women. Should do, and there's more to be done on that, but I think quotas we really need to look at. So Equality Act by itself isn't going to affect all the change we need, of course. That requires political, economic change, but it certainly could achieve more change than it does now, or has done now, if it were more robust and properly given effect to. So I hope I haven't run over time or under time, or I can't hear or see anybody or hear anybody, so I'm assuming everybody's not gone home and gone to the, oh, they can't go to the pub because they're all closed. I suppose that's the good news.
Okay. Thank you very much, Karen. I can indeed hear you, and that's perfectly timed. Thank you for such an erudite speech on the Equalities Act 2010. You've managed to, in less than an hour, go through the history of the Act, what it was intended to achieve, that it did make the law more accessible and resolve inconsistencies with the law. You've looked at the positive outcomes from the Act before you then turned to those parts that just make you shiver, and the stark statistics on the endemic inequalities within our society. And I think particularly notable of those were the mortality, the bullying, the homicides. You looked at, quite frankly, the failures of how the Act was drafted, or perhaps how society has moved on, the intersectional discrimination, the socio-economic inequalities. And before I go on to ask some of the significant number of questions, we won't keep all night, Karen, but it would be incredibly worthwhile to hear your views on this. But I've got one question for you. And to put it in very stark terms, the Act is antiquated, isn't it? I mean, it's no longer fit for purpose. So what would you do with the Act now? Would you try and tinker with the poorly performing engine, or go and buy something new that fits an outcome model rather than a treatment focused model?
I would keep some of it. I'd probably actually throw it all in the bin, because I like to write my own things. So I'd probably throw it all in the bin and start again. I mean, there's no doubt that the non-discrimination provisions, that's the prohibitions, the negative prohibitions, are important and they need to be kept. It must be right that a woman cannot be denied a job because she's a woman. We need all those provisions, and many of them are very important, will have always been there, and we need them. But I do think we need much more compelling positive action provisions, and I think they should be mandatory. The problem is, at the moment, positive action provisions are permissive, so people often don't, in fact, they very rarely use positive action. They're permissive, not mandatory. And as I say, the public sector equality duty, that is the need to have regard to equality objectives, has become really a bureaucratic mechanism. So I would transform positive action. I would make it mandatory. I would introduce quotas. I would introduce intersectional discrimination, and I would be focused on measuring outcomes, requiring public authorities and big private bodies to report, in sanctions if they haven't achieved particular outcomes. I would make it meaningful. And at the moment, as I say, I don't want to diss it too much, because it does make changes. It really is important for those who are able to come within its reach. It really is meaningful for somebody who has not been given a job because they're black, they're a woman, they're disabled, as the case may be. They can get their rights vindicated, they can get compensation. There's an issue about access to courts and legal aid, but you know, they in theory can access the tribunal, they can get compensation, and those are absolutely important and not to be underplayed. They are really important, and the indignity of stigmatizing and indignity of experiencing that sort of discrimination must be outlawed, but it's just not robust enough.
Moving on from there, one of the questions that was posed was, why do you think there is an epidemic of misinterpreting public sector equality duties by bodies, particularly in the area of sex, and how can this be improved?
I think it's because the duty has allowed it. So there's been lots of early case law that says the duty is really important, it's very robust, public authorities must treat it as substantive, it's not a tick box exercise, and I'm quoting from the case law here, it's not a tick box exercise, and so on. Anybody who does this work will know there's about 10 things from bracking, the case of bracking, and they all list them down. You know, you must take it account, it's meaningful, take everything into account, it's not a tick box exercise, etc. But actually, once a public authority has been able to say, I have due regard, I have had due regard, well, that's it, unless you can show they're dishonest, or unless you can show they really didn't, it really was just tick boxing. If they can show some statistics and say they had regard, it's very difficult, and that is because of the device used, or the mechanism. Due regard to, that is, take account of, effectively, a bit more than take account of, but pretty much. And so that's very problematic. I also sense, I don't suppose there are any judges in here, so I hope not, but I also sense a sort of weariness on the part of judges. That is, oh God, they're not coming along with another bloody public sector equality duty argument. That's not that bloody Karon Monaghan coming along, is she arguing about, or that blah coming along. They're always going on about that. And I do sense a weariness. Perhaps I'm being cynical, but I think it is, it's drafted in a way which means it inevitably is going to have limited impact. And I don't know if the courts have become a little less enthusiastic about it. Let me put it like that.
And do you think that the formulaic approach of the Act is one of the fundamental problems for the issues with intersectional discrimination? You spoke about groups within groups, and the weak duties, what they are and what they have been implemented within the Act. And there's one of the problems that if you have categories, you put somebody in a category, you tick all those boxes, okay, that's fine, we balance that, we're fine. And that doesn't really get to the heart of the intersectional issues that really are highlighted. They're always there, but they are particularly and acutely highlighted this year.
Exactly. I mean, exactly. And I mean, we were looking at the equal pay, the barristers' equal pay issue. I mean, that's really stark. I mean, black women, or women from black and minority ethnic backgrounds who are barristers, that experience would be completely lost if somebody didn't decide to undertake an intersectional analysis. It would be said, well, black people and people from minority ethnic backgrounds earn, let's say, 25%. I haven't got the figures to hand, but let's say 25% as compared to white barristers. But actually, if you unpick that, it might be, well, we know that actually it's black women who experience the greater disadvantage, and that would be completely lost unless one undertakes an intersectional analysis. Similarly, if one looked at men and said, how many men die in custody or how many men die under restraint, that would give you it would give you a picture. I doubt there are very many women at all. I can't think of any off the top of my head. I'm sure there must be, but very few women die under restraint in custody, whether that's in a mental health setting or in police custody. But if you just said men, you would lose the impact of the experience of black men who experience restraint in disproportionate numbers in police and mental health settings. So you need to have an intersectional analysis to really understand what the problem is. So I think that's a real flaw. And for some people it's quite offensive. Why am I being looked at as a part of this homogenous great group? Black people aren't one great big group. Asian people aren't one. Disabled people aren't one great big homogenous group. We all have individual characteristics. We have multiple characteristics,
which is supposed to be our strength as humans.
Yeah.
And we've looked at this as a general overview of the Equalities Act, but one of the questions actually draws down to the report that you referred to, and we are at Lincoln's Inn. We are just, sorry, 1 second.
You're being thrown out.
I have a 6-year-old. I'm supposed to come in, so I'm sorry about that. He's bursting with the teddy bear.
That was one of the lovely things about lockdown, actually, and the people started to allow their children to be visible. It's quite lovely, actually.
He's not started judging yet. Every audience will be refreshed to know. Anyway, as I was saying before I was interrupted by my 6-year-old, you referred to the BSB's report on barristers' income, and that's quite frankly a shocking report. And it's very interesting that it's said in stark terms it cannot be explained away by seniority, by geography, by area of law. So we are looking at pure out-and-out discrimination. And this is a talk given to Lincoln's Inn. There are an enormous amount of barristers and hopeful barristers in the audience. And one of the questions that was asked was, how can we begin to address this as a profession? So, Karen, can you solve that one for us?
Well, we've been thinking about that for 30 years, haven't we? First of all, if there's anybody in the audience that's aspiring to be a barrister, do it. Don't be put off by this. It's a great job. Not everybody likes it. Don't worry if you take it up and you don't like it. But if you do like it and you love it, do it. It's a great job. And things will improve. And anyway, you maybe don't look at the terrible things. Look at the positives. It's a great job. How do we do it? Well, I think we have to tackle discrimination, and that is a responsibility of each of us. It's not something that the Inn, well, of course it's something the Inns must do, but it's not something we can say, oh, the Inn isn't doing that. The Inn isn't doing that. We have to say when we see it, and we do see it, let's face it, we call it out. We call it out. We promote people who we know are really, really good, and everybody's really good, let's face it. None of us are geniuses. We're all pretty average, let's face it. But we all, we pick people up, we take them up and say, you're good, nobody's looking after you, I'm going to look after you. We are proactive. We call the Inns to account. I don't know how you get rid of, I don't know how the Inns work particularly. I'm sure I should after this long, but I don't know if you can sack the head of the Inn or something. But, you sack the end of the Inn, or you shout at benches dinners or whatever. But there has to be a shaming, there has to be individual responsibility, and that is an individual responsibility by barristers and also by chambers. We also have to call solicitors and clients out. If you get the sense that a solicitor doesn't want you or doesn't want your junior because they're a woman, because they're black, because they're disabled, you sack them and you report them, which is not very comfortable, but you do it. You complain, and I can tell you it's not very comfortable. I've done it. And we make clear that we have an individual responsibility. Lots of things are being done. but obviously not enough. And the earnings issue can't just be explained by chambers putting people into the family box or the crime box, because we know the statistics have accounted for that. So a lot of it will be solicitor and client choices. We need to get to grips with that. You know, maybe a few big cases, but it's very difficult to litigate at the bar. Very, very difficult. As in most professions, very, very difficult.
But I think one of the key messages is to call it out.
Yeah.
And actually to stand up and do something about it. I know, for example, the other day I had a mature male barrister in front of me, spent the entire time telling me that the case would be decided by, and he always used the male gender. And I got to the point of, do I say anything or not? And in the end, I just had to say, there are female judges as well, and gosh, you're in front of one. Because it was just, I couldn't stand it any longer. And it's just these assumptions and these stereotypes that we need to address as well. Yes, moving back to the questions though. One of the questions I had, and actually this has been picked up by a number of questions, which is those who are intersex or identify as non-binary, and how are they protected from discrimination under the 2010 Act?
They're subject to any case law, and there may be some case law coming up, but under the terms of the Act, so just looked at by themselves, they're not covered. So when I say they're not covered, they're covered as women or men, but not as people who self-identify as non-binary or as intersex. There is case law contending that the Equality Act should be read in a way that encompasses non-binary status and intersex status by relying on Article 14. So, you know, the non-discrimination right under the Human Rights Act. So it should be read in a way that's compatible with that. But in its terms, you know, on the face of it, it doesn't cover it. It covers sex, which is being a man or a woman, and that is defined as male or female. And it covers people who have or are undergoing gender reassignment, which is a person who's transitioning from one sex to the other. So in other words, there's no status, protected status of non-binary or intersex.
Thank you. And another gentle little question for you here.
Oh, thanks.
Will our leaving of the European Union affect the Equalities Act 2010?
It may do, and I gave a lot of thought to talking about this, and then thought, oh, I couldn't be bothered because it's just so dull. But it could do. Actually, it could do in a positive way. So in a negative way, well, first of all, just to feedback, a lot of our more recent protected characteristics, so religion, belief, sexual orientation and age, have derived originally from EU law. So those protections were required by EU law. They now form part of ordinary domestic law, but it's possible post-Brexit, eventually, for the government or parliament to say, well, we don't want those laws anymore, we're going to repeal them. Obviously, there's a transitional period where EU law will, not EU law, but those provisions that have been enacted pursuant to EU law will stay in place. Not everything's going to be repealed on whatever it is. But once we're properly out of Europe, properly out of the EU, Parliament could decide to repeal those provisions, and there wouldn't be any obligation anywhere to keep them. I think it's extraordinarily unlikely because they've become so much a part of the tapestry of our domestic law. I think it's unlikely they go. One positive thing, I'm a Remainer, so I'm not saying this is I'm a super Remainer, although I've got lots and lots of criticism of the EU, but that's another story. One positive thing is actually we could introduce much more robust positive action provisions. There are limits under EU law as to what a member state can do by way of positive action, in particular what might be described as positive discrimination. And the EU have been pretty cautious about allowing it, in particular in the employment sphere. So we would be liberated so far as that's concerned. So that's something. I thought of something positive. Okay?
Yeah. Well done, that's all I can say on that one. Right, well, as we're following a pattern of gentle questions for you,
oh God.
One of the very popular questions that's had a lot of likes is, do you think the language used to write the Equalities Act is unambiguous and easily understood?
The language of the Act. I think it's simpler than it was. I think some of it is inevitably complex because there are something, things like the reasonable adjustments duty for disabled people, or what disability means. There is, it's like looking at any piece of legislation. I don't know, I mean, you're Chancery, aren't you? I don't know, I wouldn't understand a Chancery law if it hit me on the head. So there are some things that are inherently technical. I think it's less about how it's written, although I'd be interested to see what the people who've asked the question, because it may be that I'm not thinking about something. So I would really be interested in hearing about that. Because to my mind, it's less about the language, less about the drafting. There are some cock-ups, but not major. Less about the drafting and more about the content. But I'd be interested to hear what maybe some of the questioners think. Maybe there's something that I'm missing.
Well, hopefully the person who asked that question might want to refine it. If so, I'll let you know. But another one here that I'd like the answer to actually is the comparator discriminatory?
Well, it does. It starts from the premise that you will always be measured against a norm. So if you're a woman, the norm will be a man. If you're black, the norm will be white. So we often talk about non-white people as though white is the norm and everything else is different and must be measured against that, equally treated or differently treated as the case may be. So in terms of the way in which it's devised, you can say, well, yes, actually, and I've touched upon this, it's very formalistic. It doesn't talk about disadvantage associated with one's characteristics. It talks about measuring yourself. Are you being less favourably treated than a male norm or than a white male norm? And so if that's what the question is getting at, and I think they are, I can totally agree, conceptually, it's really problematic.
And you mentioned about quotas. You spoke very passionately about introducing quotas and gave rather a large number of examples where actually they do work and they have been implemented. And somebody's asked about quotas at the bar. What are your views on introducing some form of quota system?
I certainly can't at the moment, although obviously I would be open-minded, but at the moment I can't see any benefit in introducing quotas in terms of entry to the bar. I think entry to the bar should be open in terms of qualifying, I should say. So doing the BP course, I'm sorry, I forgot what it's called, BPTC, and the being called to the bar. I wouldn't be adverse to having quotas in chambers. I think they would be they need to be, really carefully worked out, because chambers tend to be small and because the number of trainees or pupils that chambers take are very small. But I couldn't see in principle why it couldn't be said that every third trainee, whether that's whether you take one a year or you take two a year or whatever it is, every third or fourth trainee must be a woman unless you've already filled that ratio. And similarly, every X number of trainees must be black or from a minority ethnic group. I can't see anything in principle that would be problematic. I can see in principle that everybody would go bananas, but I can't see it. I mean, there was an interesting quote from Lady Hale, actually, a long time ago, about quotas. She's not in favour of quotas, or at least she's never expressed herself in favour of quotas. But she was asked about, one of the questions she was asked, I wrote it down somewhere, was that it was put to her that quotas would be a really bad thing because people would be perceived by others as being appointed otherwise than on their true abilities, and more particularly, for example, white men might think that they would be, the odds were stacked against them. And she said, I tend to think that the judiciary would be better off without prima donnas who might not apply for such reasons. So there you go. I think there would be resistance, and I think there would be complaints by people who have typically been privileged. And I think that's the way we need to look at it as well. We need to remind ourselves that this is not privileging people who have not been privileging. It's taking away privilege from those who have historically and always and still are being privileged. It's not an accident that those who are senior, in the most senior positions across the bar, across the judiciary, are white men. It's not because they've got brains the size of planets. They all do not have brains the size of planets.
Some of them do.
Some of them do.
Perhaps not a disproportionately high amount of them. But you talk about quotas, and I think that's a really interesting conversation to be had, actually. But that does go back to one of the problems with the bar are the barriers to entry, and there are clear socio-economic disadvantages and barriers to recruitment, and I don't think that they are getting better. In fact, I think they are getting worse. Is that a view that you share?
I certainly don't think they're getting better. And again, one of the things I was going to pick up on and didn't, because you just had so much, and so I didn't make a note of it, but was the bar standards have produced, I think perhaps the same time, or recently anyway, the minimum wage, so to speak, for traineeships. And the minimum wage is extremely low. It's something like 18,000. Now, it's fair to say that the minimum wage generally is very low, but that's not a reason for having trainees being paid very low sums as a minimum wage, particularly as they have to dress up in ridiculous clothes and they have to follow people around all over the place. There should be a proper minimum income. And I would like to see better sponsorship through the postgraduate training, you know, the BPTC and so on. I know Inns are very generous in scholarships. They have been historically, I was a beneficiary of one, historically been very good and are very good, but there perhaps needs to be a more systematic process towards supporting people through their earlier years. And again, in the early years of the bar, it's very difficult to support yourself if you don't have the bank of mum and dad, or the bank of somebody else. So yes, I think it's, I doubt it's easier. In fact, I suspect for some it's much more difficult, because when I studied hundreds zillion years ago, I got a full scholarship. I got all my fees paid. You know, we didn't even call them fees. I went to college and did a law degree, and my fees were paid. Not that I would have been even conscious of them. I got a full grant. I had a child quite young, so I had an extra bit of money because I had my daughter. And, you know, and the idea of a student loan, I probably, well, maybe I would have done it. I was quite reckless, but I certainly would have thought very carefully about doing it and landing myself with a £50,000 student debt. So I think probably things are harder, actually, and certainly not easier in any event. And
I guess that the unusual year that we have had with the pandemic, a year that I'm sure none of us ever anticipated we would live through, and the very sad situation for so many people, that must have had profound impact on the profession.
Definitely. Yeah, I think there's, I think it's been really hit, and I think it's been hit financially, but I also think there's a lot of anxiety about it. So there's a lot of anxiety about what's going to happen to work. I think there's a lot of anxiety about how people will manage if they get COVID, how to manage their home, their family life with their work life. I mean, we were joking about your 6-year-old coming in, but you know, if you're in, you know, if you're in the high court or whatever, and you've got somebody, you know, your partner's working on that computer, and I hear this, you know, partner's working at the kitchen table, you're telling him to, or her, to keep the child out of the way, you've got a baby's coming, you know, it's very stressful. I mean, we joke about it all between ourselves, but it's actually can be, I think, very stressful. So anxiety is about money, anxiety is about working at home, anxiety is about career. So I think we need to try and be really, really supportive of our colleagues as well, and do what we can to, and our staff, I should say as well, because I think for our staff, it's been really stressful too. They're worried about their jobs. Some of them have been furloughed. They're working at their kitchen tables with their babies. So I think we need to be, you know, as nice as we can, managing our own stress.
Yeah, I think sort of now more than ever we need to show a degree of compassion,
yeah,
for everyone. I know that it is an anxious time for our clerks, our staff, and I know with council as well, and I know for myself, I tend to go into the Rolls building to conduct hearings, mainly because it's actually far more relaxing for me to be in court than at home wondering whether my small child is going to burst through the door, or perhaps the dogs to follow him. And I had a self in front of me recently. I had so much sympathy for him. There was a mobile phone kept on going off during the hearing. And I think after the 3rd attempt, I sort of glared and just said, do you think you could turn off your mobile device? And he just said, I'm at home, I have teenage children, I can't control them. And I just had complete sympathy. So I certainly, with my hearings, when council are trying to apologise, I said, I really don't want an apology. We're humans, we're dealing with strange times. So I think compassion is perhaps one of the messages to take from all this.
Yeah, absolutely.
I think we're actually heading to 7:25 now, I'm afraid. Karen, you've been going for a while, but there are so many questions. Let me see if I can ask another one that I haven't touched on. Another small one for you, Karen, to end on. So,
oh God.
Why do you think that large public institutions like the NHS and police force still have problems with regards to equality and diversity, despite the Equalities Act of 2010?
I think it's because it's not, as I said before, it's not, well, so it's not robust enough. It doesn't have all those obligations that I've talked about. I also think in those particular, so taking those two contexts in particular, I think the supervisory bodies, so the CQC, for example, and the, what are they now called? Somebody's going to be in the, how is that outrageous, isn't it? I've forgotten what the police supervisory body is now called. They changed their name every 2 minutes.
As you reminded me, I'm Chancery, so I wouldn't know.
Oh God, isn't that awful? Somebody in the audience saying she does actions against the police. How could she not know this? Sorry, sorry. Anyway, the overarching National College of Policing, but there's another one, and used to be ACPO, but anyway, there's others. They ought to be taking absolutely firm action. It ought to be, you know, it ought to be so scandalous that the person who's responsible for the person who did it will be out, will be gone. It needs to be something that you need to worry about your job for. And it isn't. And we know there is absolute widespread discrimination, including in relation to pay in the NHS. I mean, it is endemic, and not just among lower paid workers, not that that would be okay, but it goes right to the top, consultants. And I had calls recently to look at the figures for the GMC, and, you know, doctors are hugely more likely to be subject to disciplinary proceedings in the NHS trusts, and then hugely more likely to be referred by those NHS trusts to the GMC, and then hugely more likely to be subject to investigation by the GMC, and then hugely more likely to be put forward to disciplinary tribunals, and then hugely more likely to have harsher sanctions. And that's senior doctors. So it's absolutely, that is endemic. You know, it needs to be something that is, you're out of your job, you're a chief executive of an NHS trust, a big NHS trust, you earn a mass of money, that's happening in your trust, you're out. And you need to have monitoring obligations, so you will be reporting to the regulatory bodies, and you will be reporting like the equal pay auditing provisions, you will be reporting perhaps to the Equality and Human Rights Commission, though they'd need more money. And if you were making targets, it would be a personal responsibility, not something that could be, this is one of the things with the concept of institutional discrimination, which is in very many ways positive, but many commentators have said the problem with the concept of institutional responsibility, institutional discrimination, sorry, it's getting late, institutional discrimination, is it leaves nobody to blame. And that is, you know, we need to be able to say, you're the chief exec, you're out. So yes, I mean, it is a real scandal. There needs to be much, but it needs to be, it's not just the Equality Act, it's much more robust supervision. People need to care about it. Politicians need to care about it. You know, if not, politicians are introducing legislation that cuts welfare benefits, they're going to put children and women into poverty, serious poverty, not just not being able to do nice things, serious abject poverty. And they're not really going to be worried about chief execs in hospitals. So it's a political issue as well.
Yeah.
I won't tell you whether I voted Tory or not.
I think I'd be shocked. I think that's probably the perfect way to end the session this evening. Karen, I can't thank you enough. I mean, that was just a tour de force.
Thank you, I enjoyed it. Thank you for asking me.
Analysing the Act and answering all the questions that you did. To all of the audience, I am sorry we have run out of time. I have asked a number of questions. I think we were up to 35 by the end, but that's how provocative and important what you were talking about, Karen, and how that resonates with everyone. So thank you very much for the time.
Thank you for inviting me. I've really enjoyed it. Once I worked out the tech, it was great. So thank you ever so much for inviting me. I'm sorry I can't see faces, but you know, there you go.
All right. Okay. Well, that now concludes the last of our 4 EDI forums this year. And to everyone who have been repeat attendees and those that are new, thank you very much for joining us. There will be more next year, and we do not intend to be mild-mannered about issues that are so fundamentally important in society today and in the barrister profession. So thank you very much, everyone.